In this case, the plaintiff company was one of four prime contractors building the New York City Police headquarters in the early 1980s. They were responsible for the heating, ventilation, and air conditioning of the building. Their contract with the city included a no damage for delay clause, which said that if the city caused delays in the project, well, then the city would not be able to sue the contractor for late performance, but equally, the contractor would not be entitled to sue the city for the extra costs incurred as a result of the delays, costs such as additional wages or additional equipment hire and so on. The clause read as follows: the contractor agrees to make no claim for damages for delay in the performance of this contract occasioned by any act or omission to act of the city or any of its representatives, and agrees that any such claim shall be fully compensated for by an extension of time to complete performance of the work as provided herein. As it happened, there were many delays to the project. The city revised the plans many times, and there were coordination issues between the plaintiff company and the other prime contractors. The project went more than 2 years past its schedule. The company sued despite the no damage for delay clause. Judge Fuchsberg said, "An exculpatory agreement, no matter how flat and unqualified its terms, will not exonerate a party from liability under all circumstances. Under announced public policy, it will not apply to exemption of willful or grossly negligent acts." More pointedly, an exculpatory clause is unenforceable when, in contravention of acceptable notions of morality, the misconduct for which it would grant immunity smacks of intentional wrongdoing. This can be explicit, as when it is fraudulent, malicious, or prompted by the sinister intention of one acting in bad faith, or when, as in gross negligence, it betokens a reckless indifference to the rights of others, it may be implicit. The judge found that this had not been properly explained to the jury at the initial trial, and so by majority, the Court of Appeals returned the matter to the First Judicial Department of the Supreme Court of New York for a new trial. From this case, we confirm that exculpatory clauses in contracts cannot exclude liability for, among other things, gross negligence.